Good afternoon, everyone. Good afternoon. Welcome to Law and Orders, Best Practices for Drafting, Formatting, and Getting Your Orders Entered in Bankruptcy Court. I'm Ala Policastro, CLE Advisor for the Beverly Hills Bar Association, and today I am delighted to introduce our speakers, Judge Sherry Bluebond and J. Scott Bovitz. Judge Bluebond was appointed to the bench in 2001 as a federal bankruptcy court judge for the United States Bankruptcy Court, Central District of California. Prior to taking the bench, she was a partner in the law firm of Irel Manella, where she co-chaired the Creditors' Rights and Insolvency Group, specializing in bankruptcy, debtor-creditor relations, and business litigation. She's a graduate of UCLA Law School, where she earned numerous American Jurisprudence Awards and graduated first in her class. Judge Bluebond is a fellow of the American Bankruptcy College and a member of the American Bankruptcy Institute. At various times, she has served in leadership roles in a multitude of professional and philanthropic organizations focused on bankruptcy and finance on the one hand and child welfare on the other. And our next speaker, J. Scott Bovitz, is a certified bankruptcy law specialist and partner at Bovitz and Spitzer. Mr. Bovitz has dedicated 45 years of his career to federal practice in bankruptcy court. In that time, Mr. Bovitz has been selected as a Southern California super lawyer in bankruptcy and creditor-debtor rights every year since the program arrived in California. He is a prolific author and speaker on topics related to his bankruptcy expertise, frequently being sought to share his insights at bar associations, conferences, and law schools across the country. Mr. Bovitz has also served as an adjunct professor at multiple law schools and is one of the most sought after bankruptcy mediators through the United States Bankruptcy Court's mediation program. We cannot wait to hear what they have to share with us today, and now I'm turning it over to them.
Thank you very much.
Rin, could we have slide 3? Judge, I'm going to talk about this rebus in a second. We can let people look at it, but I'm not sure that you know, but for a long time, I was a few floors below you when I was at Shea and Gould, and we both were right across from the mall there in Century City, so we have kind of parallel paths on this. But the thing that I'm always most impressed about is that you are a creative person. Somehow you fell into the law instead of painting or something. And you would occasionally, as a game host, recurring game host for the California Bankruptcy Forum, you would require people to do puzzles and do other things to win prizes. So what is this?
Well, actually, let me just clarify that statement a little bit. We have contestants compete to reveal to win a game, but then the answer to each game would have been related to the topic that a judge would discuss, a case that a judge would be discussing. So it's always an educational game show. And frankly, there were prizes, but generally everybody got the same prize just for playing, participation prizes. So hopefully now that you've all had a chance to look at this on the screen, you've figured out what this common bankruptcy phrase is that I've illustrated this way, but I'm gonna give it away for those of you who haven't. It's violin less in, so that's lay, and that's a bun. It's a b, but you're changing the b to sh, so shun, violation. And then in Latin, eggs are ova, so violation of a, and that's a dish and a charge. So violation of a discharge. And then ink minus the K is in. Skunk, where you change the SK to J, in junk, and then that's a none, but the none is SH, so that's injunction. So violation of a discharge injunction. I have to say, this was a very hard game. The panelists would have to answer to match, to turn over squares, and then they'd see part of the puzzle. And I'm not sure, but perhaps once they saw the entire puzzle, they still had no idea what it meant. So that might have been a little bit too hard, but you've been very flattering to me, Scott. What you haven't mentioned is you're very artistic in your own right. You have at bovitz.com, you have what, about 700 songs that you have composed?
771.
Okay, well, there you go. In all different genres that can be licensed in some instances for no cost to be used as background material for your various different video performances and anything else. So
The American Bar Association.
bovitz.com.
The American Bar Association uses the background music, one of my songs, in the Bad Boys of Bankruptcy podcast, which kind of thing. Rin, could you bring up slide 5?
Before we leave that, one other thing, I'm not sure you mentioned that Scott Bovitz is also a fellow of the American College of Bankruptcy. Anyway, all right, thank you. Next slide.
The way this program came about is every time I'm in Judge Bluebond's court, she's instructing us on some aspect of procedure or practice. And the one area where we seem to muck it up, the blocking and tackling that we just don't do a good job is in preparing orders for the court. So I was thinking, Judge, is it really a big a problem? What do you have, a couple of draft orders a day, so you spend 15 minutes, no big deal? Is that the way it works? Rin, you
Not
can
quite.
drop that slide.
Yeah, not quite. There's actually several steps. Several people along the way can be annoyed by an order that doesn't work right. There's 3 different people that touch orders when they come to us. And I'm assuming you're doing this through the Lodged Order Upload program, our LOU program. If you're lodging hard copy at the filing window, that's the old-fashioned way, and then we got to deal with marking it up and scanning it and everything else.
Okay, hold on a second.
Yes.
We could send in a draft order to the clerk who would do something with it we don't know, and you're going to explain that. Or we have an electronic system, LOU, because everything in the government has abbreviations, right? LOU,
Right.
where we do something. We're going to go into those details, but go ahead.
Yes. Yeah. So when an order comes in through LOU, my courtroom deputy looks at it and she'll kick it if it's messed up in certain ways that we'll talk about later. My law clerk will then review it to make sure substantively it's okay, and then I look at it. And so I don't even know all the ways, although we're going to talk about it, and I've found out some of the ways that you can annoy the 2 of them. But when I get the order, I'm actually sitting at the computer and fixing the things that don't work for me. So yeah, I don't just get 1 or 2 orders a day. I get somewhere between 8, 10, 12, whatever orders a day. And some of them are more annoying than others. And we're going to talk about the things that you can do to keep from annoying the judge. Because last thing you want to do is have a judge cursing under their breath at you based on the way you've lodged what could have been or should have been a very simple order. But instead, you've turned it into something that makes me gale. So yes, we're going to try to help you avoid that.
Please mark that moment. That's the first time that you've seen a judge actually do the lion's roar there with the teeth and all that. So one of the ways that the Central District of California has done something that other courts mock us for is we have standardized forms for the most common motions and orders. And these are available on the Central District of California website, right? Central Bankruptcy Court, not the district court. And we got a boatload, and we've got different search. Sometimes you have to search 3 different places to find it. I don't know why that is, but you do. And so you put in the magic word and you eventually come up with a form of an order. Judge, if there's a standard form of order that's on the website, are we supposed to use that rather than some custom Bovitz version that has lots of good stuff in it?
Well, all of our forms, not just the orders, but all the forms will say in the footer whether they're mandatory or not. And if it doesn't say mandatory, you don't have to use that form, but it's certainly a good idea to look at the form and make sure that if you do the Bovitz version, that you've included everything that we wanted in there. Otherwise, the judge is going to have to add that. And if it says mandatory, it means mandatory. And we'll bounce it or deny it, or it won't get entered if it's supposed to be mandatory and you don't use it. So for example, our orders on motions for relief from stay, those are mandatory form orders. Now, we've started doing, my chambers happens to do our own orders on motions for relief from stay, just because it was back during the subprime meltdown. We were doing 80 stay motions on Tuesday and 80 stay motions on Wednesday. And believe it or not, the time that it took to prepare the orders ourselves was less time than it took to chase 160 lawyers to get all of the orders lodged. So,
okay. So we're going to talk about the time period. We have a window, hopefully within 7 days, and you tell us, and we're going to talk about who does the order and all those things, those details. Sometimes, though, we get confused between orders and judgments. Marin, would you bring up slide 6, please? The next slide after the wizard. Okay. A judgment is entered, what, in an adversary proceeding, and an order is entered in a contested matter or something else. Is that how it works, Judge?
Basically, you're not going to see a judgment and something called judgment unless it's in an adversary proceeding. But if you're in an adversary proceeding, the judgment is the thing that happens at the end, unless you might have a partial judgment, you might have a partial summary adjudication. So you might have something that has the word judgment in it. But generally in an adversary, the judgment's at the end. But don't forget, you can have motions in the context of an adversary proceeding.
A motion in limine.
Motion in limine, or a motion for leave to amend, or a discovery motion, or, so there will be, or can be, an order on that motion. So there can be orders Orders show up in both contested matters and adversary proceedings. Judgments only show up in adversary proceedings.
Sometimes you have a very special kind of order that we're going to mention in passing later, the pre-trial order, or maybe in some judges, it's pre-trial stipulation with an order on that. I don't know. It's confusing to me. Should I be doing a proposed pre-trial order in your courtroom?
Yeah, this is very judge specific. There is, as you just said, there's two different procedures described in our local rule. I think it's 7016-1. Either you do a pretrial stipulation with an order saying it's so approved, or you upload the order itself. I'm one of those judges that wants the order uploaded itself. And the reason for that is that the pretrial order, I'm not just talking about a scheduling order. The pretrial order that we require in every adversary proceeding, or at least I require in every adversary proceeding, most of us do, 7016 tells you what has to go in there, but it's basically a list of everything you agree on and everything you disagree on.
He's a chump. He won't agree on anything, Judge. Why am I going through this?
To try to narrow the issues so that I know what I'm actually have to do at trial. If you guys can't agree on it, that's one of the things we'd be talking about at the pretrial conference. But 2 weeks before, and I've even sent parties to mediation to try to figure out what goes in the pretrial order because they were that hopeless. But generally,
Wow.
It's everything you agree on goes on the list of the things you agree on. If it's the stuff that you don't agree on, it goes on the list of the stuff you don't agree on. And the reason I want it uploaded instead of just filed is because I want to be able to use the benefit of the fact that orders get uploaded in our Lou program in Word so that I can modify the text. So when the issue of when the bankruptcy was filed shows up on the disputed list, and I say to the parties at the pretrial conference, how can this be in dispute? It's a knowable fact. Then I can make a change. I can actually fix it. And
I've been there when you've done this.
Fix it. Yeah. If it's hopeless, I send them back to the drawing board, give them a new deadline. But if it's just a little tweak here and there, I can fix it myself.
Okay, so we're coming in from the 10,000-foot view, and we took a little side trip into the pretrial thing. Rin, could I have slide 7, please? Rin is our really super helpful Beverly Hills Bar Association person, and we're so grateful for her. Judge, there's this central guide of some kind. The central guide it's not the local bankruptcy rules, it's not the federal rules of bankruptcy procedure, it's not the federal rules of civil procedure, but there's a central guide which we've quoted from extensively in our slides. What is that?
Well, it's kind of the how. The local rules are the what you're supposed to do. The central guide is kind of the how you're supposed to do it. And the thinking that went into that division is that they've made it a little bit easier for us to do, but our local rules, changes to our local rules, technically have to be approved by the district court. So we don't do that every 2 weeks. That's maybe once a year we go through that exercise. So, and it requires not only our rules committee, but their rules committee, their executive committee. So it's a big to do. We don't like to change that regularly. So if, for example, the U.S. trustee moves and decides that you need to send their copies to a different address, we don't want to have to modify our local rules for that. So anything that's sort of like how, where, how many copies, just little more detailed stuff, we put in the central guide because we can change that whenever we want to. We don't need to get approval from the district court to deal with that. It's the mechanics, if you will.
I know, this is quite a change from when I started and when you started, where the court says, hey, we don't practice law. You go take care of that. We'll either bump it or we won't. And by doing this, the benefit to the court is you don't waste your time on as much stuff, because if somebody will go onto the central district site, will read the page on the central guide about the 10 steps that have to happen for whatever, then it makes your life easier, your clerk's life easier, and maybe it helps the system move along. And I find it to be fantastic. The bankruptcy appellate panel in the Ninth Circuit has a kind of to-do thing. It's primarily authored by Susan Sproul, who's the clerk of the court, with the assistance of the various staff attorneys over there. And it's similar, but it's a sort of a long chat. The central guide is discrete. So you could say, for example, Rin, let's bring up slide 7. You could have a question. I could say, who prepares the judgment or the order? And by gosh, on the central guide, it says the order of judgment may be prepared by the court, which is, Judge, you'll tell him if you're going to do the order, right?
Right, right. We always discuss at the end of the hearing who's doing the order. I'll either say the court will prepare the order, I'll say, so-and-so, you'll prepare it, or like yesterday at a hearing, I said, can I get a volunteer? Who will do the order? So.
Okay. And when we have an order that we want you to look at, we're not filing it, we're uploading it through the LOU system. It's called lodging, right? That's the magic word in connection with that. And when you have edited my beautiful draft order that somehow, I don't know, you didn't like it the way it is, does it always say on the front page, changes made by the court and some crazy stamp, or do you just say whatever and enter it?
It doesn't always say that. It may say that if there's something I want to bring your attention to. And maybe the changes will even be in bold or underlined if it's something I really want to bring your attention to. But can we not gloss over something you just said a minute ago? Because this is something I encounter a lot, which is
yes, I would like to not gloss over
lodging. I've got it later in my notes, but I'm happy to do it now. When you just use CMECF and file something, it ends up on the docket magically. Okay, that's there. I don't spend all my day reading through my dockets to see if there's anything there. Okay, but if you want the judge to look at an order and sign an order and get it entered, you need to lodge it, which is our LOU lodged order upload program. Or please don't do this, but you can hard copy at the counter. Okay. Now, we have this procedure called a notice of lodgment, and I know I'm getting ahead of myself a little bit here, and we'll see one later. But the notice of lodgment gets filed. And it tells the parties that you have lodged the order, but it isn't the lodging of the order. You still have to lodge the order. In fact, if you file a notice of lodgment and then don't lodge the order, you're lying. But the benefit of that is you can use our automatic electronic service to send a copy of the proposed form of order to the other parties. That's how the parties know that you're asking me to sign an order that looks like that. And we have preserved for the record what it was you asked for, so that if anybody ever wants to see what changes I made compared to what you filed, you've got both documents will exist there. And in terms of, there is a box I can check when I'm approving it that will put a little box in the upper right-hand corner that says changes made by the court. If I'm making just formatting changes, little nothing, somethings or others, I won't check that box. If I've changed a continued hearing date from the one you asked for, I'm going to definitely check that date with the hope that you'll notice. I might even put the date in bold. Or if I've deleted something I think you really wanted and I didn't like it, I'm probably going to check that box. But if it's something that's no biggie, I probably won't.
So I hope we have some young lawyers who don't do this all the time, as well as some grizzled veterans. But with respect to the young lawyers, it's very confusing when you start out, hey, PACER, what's that? You get to look at a docket. You get to pull a document down and pay for it. And then you got CMECF, which is some sort of magic thing where I'm designated to be a clerk of the court for just that moment, to be able to actually upload something into the electronic file, and it shows up on the docket, unless some clerk in quality control decides that I'm a buffoon and I did something in the wrong case, in which case it might disappear. And then a whole separate process for orders, LOU, which is putting up a Word document for you to edit. And if we're really lucky, you edit it and then you authorize, below my number signs that are at the bottom, which we'll talk about, you're going to authorize it to be entered. Then I don't do that. It gets entered by the clerk over there. Your team enters it. Now it shows up on the docket, so somebody in Virginia can go to PACER and see that an order was entered. So we know there's a motion, there's a hearing date yesterday. You may or may not put something on the docket to remind yourself that you granted the motion or you denied the motion or you set a new date. Sometimes that's there a lot, and that's very helpful. But then
we call those hearing helds. We call those hearing helds. There'll be a docket.
Some judges put more than that. Judge Clarkson, for example, will essentially put a minute order in there, but that's not the order. That's just an entry on the docket. So it's a little confusing. Rin, could you bring up slide 8, please? By the way, this is an 8-hour program. I hope everybody knows that.
Yeah, at this rate, it will be.
No, we're covering a lot of stuff later, so we'll be able to do that. Okay, so we had talked about on slide 8, your proposed pretrial order in adversary proceedings, sometimes in contested matters where you're treating them like an adversary proceeding, which you can, maybe a complicated homestead case or something. You're going to require a set of stipulated facts and disputed facts that will guide you, judge, during your trial, right? And so the question you asked that you, when we were preparing for this, is that fact really at issue, counselor? And, you give that look, and of course, counselor says, no, 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 I guess we really don't debate when the petition was filed. And it goes to the, to the stipulated facts in this. Now, if I'm going to have a pretrial order, that's one of two times that we would like to upload it before the pretrial conference, right, Judge? And then there's the other one about first stage. Would you talk about that?
What, first days you want me to talk about?
No,
Yeah.
talk about why do we do that? We do it because you can edit them, right? Go ahead.
I do, right. And I have a chance to read it too ahead of time too, as opposed to a pretrial order. Again, the concept is we're trying to figure out what the dispute is really about, as opposed to another kind of order where I'm memorializing what I actually did at the hearing. That's something that we don't really know what I did until after the hearing for the most part. We're about to get to special case number 2. But for special case number 1, I want to see the pretrial beforehand because I want to see if I understand what you're saying, what the dispute's about, and whether you've covered really what is at issue. And sometimes I'll read an issue and say, what do they have the disputed issue of fact is whether, defendant defrauded plaintiff by saying X on such and such a date. Okay, but what's the issue? Is it whether he actually said it or not, whether he said it on that date, or whether it was true or not? So I'm going to want to read through it and figure out the questions that I have for the practitioners in order to make the pretrial order actually say what it needs to say. So I need to see it before the hearing so I can prepare for the hearing.
The other one was first day orders. And first day orders, we're talking about a collection of motions that are commonly filed in the beginning of a Chapter 11 case, right, maybe especially an operating case. And there's a lot of stuff that needs to be done right away. Permission to use cash collateral. You got, lettuce rotting on the dock. You got employees who need to be paid. And so, Judge, you're saying with respect to that, okay, please show me the proposed orders. Does that mean we file them as proposed orders on, CMECF? Or does that mean we LOU them up to you?
It's kind of up to you in the sense that the faster you want it, the more like, it's a good idea to have uploaded it. You for sure if you want me to enter something right at the hearing, it needs to have been uploaded for me to approve it then and there. And you need to have sent it to the other side. You could be, if you're physically in court instead of on Zoom, you could hand out copies before the hearing if they're there. You could have emailed them to parties ahead of time. But if you want something entered at the hearing, you got to make sure, 1, that everybody's seen it. And number 2, that it's available for me to act on. I don't really care. I mean, you're the one who needs to pay your employees and you're the one who needs to, So if I'm happy to say lodge the order after the hearing, but if you want me to act on it immediately, then it's going to need to be there. But I will let you in on a little secret. Well, maybe, were you going to say something, Scott?
I was going to say, wow, I can get you to sign an order on the bench. That's really important.
If there's a reason for you for us to do it. And yeah, if it's on the other hand, if it's just you're doing that all the time, I might find that annoying. Once upon a time, we used to talk about, remember walking through an order when it was really urgent? There is no such thing anymore because there's nowhere for you to walk. You could, if there's something that you wanted to do a walkthrough for and it's that urgent, I could approve it and then you can wait on the 10th floor and they can get it entered and print you a copy. But I guess that's the closest thing to walking through an order. But the secret I was going to let you in on is one of the reasons, and this may not be the only, but look, okay, there's 2 reasons that we probably, other than these special cases, don't want you uploading the orders ahead of the hearing. One is we literally have a queue of all the orders that have been uploaded. And the longer it gets, the harder it is to find the one we need to find. So we don't need extra orders in there that aren't what we actually ordered. So like I may deny your motion. I don't need your order granting the motion sitting in my queue. It just means somebody's going to have to look at it, look back, see what I actually did, and tell me to delete that order. So it clogs the queue. The other reason that some judges, I personally don't care, but some judges may not want you logging it, uploading it ahead of time. They keep statistics, and we look at our own statistics on how many days from the time an order is uploaded till it's reviewed, checked in by the courtroom deputy, reviewed by the law clerk, and then approved by me and entered. And we keep track of judge average, division average, district average. Some judges are very competitive you upload that order early, I'm not going to sign it. And it's going to screw up my statistics. It's going to mess up my averages by having an order that's there for 21 days instead of the ones that are there for a day or two, because we turn those orders around if they're ready to be entered.
Well,
So, we'd rather have an average of 1.42 days than an average of 10 days. And nobody's looking over our shoulder, really. It's all internally, the competitiveness. But, some people care about that.
in the olden days, going way back into the 80s, every now and then an order would get uploaded and it gets signed. Sometimes you'd have a grant and a deny order issued in the same case because it was a mess. And it's not because judges or clerks were incompetent, it's just the bunch of law. Let's look at slide 9, Rin. Judge, there's something else called findings of fact and conclusions of law. And sometimes I see an order or proposed order that has not only motion granted, but it has a bunch of other stuff in it. Is that the way to do it?
Well, it's not the best way to do it. Frankly, I draft my own orders that way sometimes. But you are supposed to make findings of fact and conclusions of law. They can be done orally. And the easy way to do it is to have the order say, for the reasons set forth on the record at the time of appearing, it's hereby, ordered as follows. I mean, that's the easy way to do it. Now, if I know that the matter is likely to be appealed, and I want to make sure that it's convenient for the district court or the bankruptcy appellate panel to know why I did what I did, I may want to do findings. Now, it's better for them to be in a separate document. And we generally do that after a trial. There'll be findings of fact and conclusions of law, and then the judgment or the memorandum, or we often will do that at confirmation, findings of fact and conclusions of law in one document, confirmation order in another. And that's actually the better way to do it because, let's see, I made a note of this section here. FRCP rules 52 and 58. The judgment may not be considered effective and the appeals period may not start to run if you have combined them and until there's like a drop dead date of 150 days. So it doesn't invalidate the order. The order is still good, but there is an argument that you have given the opposing side who lost maybe up to 150 days to appeal if you don't put them in separate documents.
That's for the grizzled veterans who found themselves stuck in this program. They just want to hear your tips to connect with that. Rin, would you bring up slide 11, please? I'm just going to skip a slide, go to slide 11. Okay, this, the Federal Rules of Civil Procedure apply most of the time and mostly through the Federal Rules of Bankruptcy Procedure, right? And here's one that applies, 52A3, that says, hey, you, judge, are not required to state findings or conclusions when ruling on a motion unless the rules provide otherwise somewhere or any other motion. So this is different than an adversary proceeding trial for non-dischargeability or fraudulent transfer where you're going to enter a judgment and you're going to make some findings and conclusions on the record or otherwise. But do you do findings and conclusions? I think the answer is yes, because when you come out with your tentative ruling, you're telling us where you're going to go and ultimately what you do. Go ahead.
Yeah, I was going to say there is a judge who is now retired who I never appeared in front of this judge, but rumor has it that he would listen very politely to all of your argument and then say motion granted, motion denied, and just leave the bench. I would never do that. First of all, I don't want the parties being confused, and I have this fantasy that if I present my reasoning well enough that it reduces the likelihood that the losing party will appeal. But it also gives the appellate court no idea whatsoever why you did what you did. And now it's true that the appellate court can sustain the ruling on any ground, even if it's not the ground you used. But what if they don't think of the ground you used and you were actually right, but it didn't occur to them? So I always explain the findings that I'm making and the conclusions that I'm making, or why I don't need any findings, because this is all a matter of law. Because I want to know, the parties to know why I did what I did, and I want the appellate court to know why I did what I did.
Well, and we want to preserve that information and have it. In fact, Judge, this sort of goes to the drafting of the order. Okay, maybe you don't have all the findings of fact and conclusions of law in it, but when you are going back to review and analyze or interpret your order or something else, you want to make sure you can pick up the order and understand what you did, right? That's your personal preference. So if the order simply says motion docket number 11, granted, that doesn't tell you anything. You got to go back and read something else. And it's so you want more precision in the order and maybe a little bit of the why. Am I right on that?
Not really. No, I mean, I
Okay.
have preserved, I not only have the tentative ruling that lives forever in the system, it won't live on the record if, unless I read it into the record or attach it to an order, but it lives on so that I can find it in our systems. Of course, I guess I should break the news that at some point in the next couple of years, there'll be a new, instead of CMECF, there's going to be a new CMM. Yeah. And who knows? And then we're going to have to change our calendaring system, and we will have a lodged order upload program too. But maybe I won't have the historical tentatives. I don't know. But what I will have every time I still like paper. So as I'm having hearings, I take notes and I note what I did, and it's on a copy of the tentative ruling, and we scan those and save those. So I have at least two different ways to figure out that the handwritten notes are better because it not only has the tentative ruling, it has what I actually did notes. And then that is given back to me when I look at the proposed form of order. So especially in routine matters, I don't want anything more than, here's this hearing came on for calendar and here's who was there, or appearances were as noted in the record and for the reason set forth on the record at the time of hearing and other good cause appearing therefore, it's hereby ordered, boom, 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 boom. I don't need that in the order. But sometimes I want to, again, make sure the parties know, and I want to make sure the appellate court knows.
Do I need to say who was in the hearing, at the hearing?
I don't know that you do. I mean, I remember once upon a time we always did. Now I see more often appearances were as noted in the record. And I guess the only time I would say do it is if there's somebody who might claim later that I wasn't there and I didn't know and I'm not bound and I've been, my due process rights were violated. Maybe it's helpful to have right there in the order, so-and-so was there at the hearing. But other than that, I'm not aware of, there may be a reason, but I'm not aware of any reason why appearances were as noted in the record isn't sufficient.
Should I say it was opposed? The checklist in our standard form say the motion was not opposed, the motion was opposed.
If there's a written opposition, sometimes it might be, you could say the objection was overruled or the opposition was overruled. But I mean, I think that, or what I generally do when I draft something, I'll say, the court having reviewed and considered the motion, all papers filed in opposition thereto, and the replies and all supporting I mean, I may say that, but the appellate court's gonna presume I read all that. And if I didn't, and I still granted the motion, okay, well, if it's an error, it's an error, and if the appellate court wants to fix it, they can fix it. But I don't know that there's any magic to whether the order says that or not.
Okay, let's look in at slide 12. Judge, I want to talk about preserving your tentative. You mentioned that. Okay, so if you did a tentative, and you often do, something that's thick with information, not in every case, but you have the stuff that we can all read and understand before we come to the hearing. Why don't I just say in every order that I say my motion was granted or whatever, that, exhibit A, for the reasons set forth in exhibit A, you don't have 11-page tentatives usually, but why don't I just do that? And I can upload a Word file and attach a PDF to go with it. That would be my PDF. Isn't that a good practice?
You can. I don't know that it's necessary in every case. And the one caution that I would have and the one objection the court might have is one of the reasons there was a major cost savings when we went from, remember, like stipulations and order used to be a combined document, and now we have a separate standalone order. The orders are shorter, and we actually have some people that we have to mail things to. Not everybody gets electronic copies of things. So there's people who get hard copy mailing, and the government has to pay postage for that. So we tend to try to avoid long exhibits. That's why there is a rule about only 10 pages of an exhibit, is because we don't want to pay the postage costs. And our district alone saved millions of dollars when we went to, please don't put long things on your orders. Same thing with like a settlement agreement. If you've approved the settlement agreement or the plan confirmation, instead of having it attached as exhibit, better to have it refer back to exhibit A to the motion or the plan filed such and such a date, docket number, whatever, so that we don't have massive mailing costs when we're sending that out.
Yeah, there's sometimes when you're going to want to have that, we're going to want to have that, and so we're going to cause you grief by doing that. But I thought an example on slide 12 that was real nice. Here it is. This is a quote: "Deny request for relief under section 362D2 due to existence of equity, but grant motion under 362D1 without a waiver of Rule 4001A3 as movement lacks adequate protection." That's a quote from an actual order. Wow, that's just simple. Tells you exactly what you were thinking. It tells you what the conclusions were. It gives that. Now, this is a language, a custom language, right? Not our standard form for relief from the automatic stay. But is this kind of a good model?
Yes, except for motions for relief from stay, because there's mandatory form orders. And there'll
Right.
be a box that I check for granting D1. There'll be a box I check for denying, or I won't check the box for D2. And then I'll either check the box or don't check the box for waiving the 4001A3.
I'm
So,
with you. I'm just talking about the kind of the flow of an order. Okay, you refer to a motion by a docket number, then you say, review the things, and then you have a little bit of a ruling, okay, that you go in here and then put at the end, so ordered, I guess. Do we still need to say so ordered at the end?
no, you don't need to say so. It is so ordered at the end. Sometimes it's there for like, well, I don't know how to explain, like symmetry, or just sometimes you end with something where you just want to draw an underline and an apostrophe at the end, not apostrophe, an exclamation point at the end. That's kind of what it is, but I can't, it's absolutely not required. Let me go back to the question though, should you just like lift and copy something like this? If I were drafting the order, I would say the court having, the motion came on for hearing, the court having found that there is no equity, or that there's an adequate equity cushion, or that there's no reasonable likelihood of reorganization within a reasonable period, and other good cause appearing therefore, it's hereby ordered that it's granted under this section, denied under that section. I usually don't combine the reason with what I'm actually doing. I usually put the reasons up before the "it is so ordered," and the actually what I'm ordering after that.
Ren, let's bring up slide 13. Judge, you spent a lot of time and attention on preserving exhibits from contested matters, exhibits from trial. In the olden days, we had notebooks and they had exhibit tabs, and gosh darn it, I guess they sat around if there was an appeal in some rolling cart in your jury room that you don't use, waiting for someone to tell you that the appeal is over in connection with that.
We
But
do use the jury room. My staff eats lunch there and they use the bathroom. So the jury room does get used.
But how do you preserve these exhibits? Do you do electronic trials? Do you preserve, what's your thought on preserving exhibits in connection with this? Do you stick them somehow, to an order? Oh, hey, because of this great contract, exhibit 1, attaches a PDF to an order. Is that what I do?
Yeah, this is a whole program on itself, and there is a working group right now in the Ninth Circuit working on like the best way to do this. But in the meantime, this is what I do. I do have the parties. I think it's important to bring an exhibit book if you've got a witness, unless everything is all electronic and the witness has a screen there too. And sometimes I do Zoom trials, so that's the way. And I do have the parties exchange exhibits electronically, and I have them email exhibits to me to a special email address. Now, none of that's on the record yet, but then we all have them electronically. And then after it's over, the exhibits that are admitted, and I suppose if there was a big dispute about whether something should be admitted or not, I have the courtroom deputy upload those to the docket, so they're actually docketed. But different judges do it differently. But it is a good idea to have the electronic copy preserved. And if there's not that many, they could be just one clump of exhibits. If they're lengthy and they may need to be separate ones, there's different ways to do it. But like I said, that's a project in flux, and there hopefully will come up with a great system for doing it. We're kind of doing it on an ad hoc basis now. Everybody's doing their own thing. So ask the judge.
The Beverly Hills Bar Association will do a program next year on what every judge is doing to preserve exhibits, paper and otherwise.
That's an excellent thing to discuss at the pretrial conference. Is how are we going to handle exhibits? And I also do a trial procedures order that will explain what I want the parties to do with the exhibits.
Right. A lot of judges have special rules for contested matters and adversary proceedings. Rin, let's look at slide 14, please. Rin's the best. A round of applause in your seats, please, for our Beverly Hills Bar Association right arm. Judge, this is just golden. Drafting a proposed order tips, okay? We've got a couple of these connected with that. Prepare the order in Word. Judge, I'm going to use my, something other than Word. Okay, Word Perfect 5.1, why can't you use that?
Well, I could, but it's not the system. I don't think accepts it, and it'll get bounced. If the courtroom deputy would bounce that one because they'll turn. I happen to have gotten special dispensation to continue using Word because my law clerk has some programs, some things in Word, but the whole we're all I sorry Word Perfect. We're all on Word now, and it won't work. When the courtroom deputy tries to call the order up to do anything to it, it won't open right. So yeah, no, it doesn't work.
Okay, so now second point, use 14-point font. Wow, that's really big. I know people from very large firms who think that that's just not, not appropriate. We're going to send it up to you in 11-point font. Is that something you care about, the font size?
Within reason. I think I probably prefer 12 than 14, but I certainly don't want read the part in parentheses there. There's one practitioner who shall remain nameless. You know who you are if you're out there. He likes to do the first letter of the order, ginormous. I don't know. It's like 40-point font. And then it screws up the spacing for the rest of the order. Every order, and this person appears in front of me regularly. Every order, I delete it and I put it, and sometimes they even check the box, change is made, in the hope that he'll get the point. It's just, as I said, this is not an illuminated manuscript. We don't need it's pretentious. It looks ridiculous.
Okay.
Can I rant a little bit more on the next
Yeah.
point? Just yesterday, I tried, this was the simplest order. It was either a schedule. Yeah, it was an order on a stipulation to continue a hearing. I mean, it was a nothing, super easy. But whoever did this order didn't know how to use columns and didn't know, I don't know how they were doing their lines and numbers on the left-hand side of their page. But on the first page, I tried to add date, time, and place to underneath the caption, and it screwed up the numbers on the left because it wasn't columns, it was across each line. Okay, so I had to figure out how to do that. Then on the second page, I didn't like the way the paragraphs they were spaced funny. I tried to fix it. I couldn't fix it without messing up the lines and numbers on the left hand. It would go 1, 2, space, 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 3. I mean, so please take a class, learn how to do this in Word. Find an employee in your firm who knows how to do this. Don't upload garbage to me, because if I need to try to make a change, I don't want to spend 20 minutes trying to figure out how to fix what you didn't know how to do in Word. So, and then as long as I'm ranting, the gratuitous Latin phrase, that same one who uses my illuminated manuscript there, routinely puts a little Latin phrase up at the, now, I guess I could tell my staff to take it out. I guess I could also tell him personally, please don't do that. But I thought he'd notice after I've deleted every single one that he does every time that he shouldn't do that. But yeah, it's an order of the court. I don't want it to say funny things and I don't want it to look silly. So anyway.
Okay, Judge, I think your favorite point, the point that really is the reason we're doing this, is should I use the word proposed before the name of my order? That is, here's my Word document, proposed order granting motion, blah, blah, blah.
Yeah, no. I mean, I think that was a nice thing back when we used to serve things by mail on each other as we were lodging them, so that you could see, oh, look, this is just the proposed version. It's not the entered version. But even then we had to cross it out and initial it. Now it's just one more thing for me to do. Of course, it's proposed. You've attached it to a notice of lodgement. You've uploaded it through Lou. If it was already entered, it wouldn't be in my Lou queue. Once I enter it, it disappears. So it just gives me that and footers. We don't need, we used to use blue backs.
Wait, no, I put a footer.
Footers, yeah.
I'm sorry,
you can use the footer with your code number of what. You can use the like on your left-hand side of so you know what the document is in your system, but I don't need the name of the order in the footer, because then if I change the name of your order, then I got to change the footer too. And by the way, can I get a little ahead of ourselves, or maybe it's here? Your title of the order doesn't need to be 8 miles long, okay? It doesn't need to exactly match everything you're asking for. It can be a condensed version. And please don't give me order granting motion for order granting whatever. I mean, that's just order granting extension of time. You don't need yeah. Anyway, it can be shorter. It doesn't need to be, you don't need to repeat your entire argument in the caption in boldface font. So thank you. This is very therapeutic for me. I don't know if anybody's learning anything, but it's very therapeutic for me.
Rid, could we bring up slide 15? I told you, Judge, that this is going to be the most fun that you're going to have in a program for a long time, because it's the things that you want us to know and we need to pay attention to. And by the way, you had some input with respect to the format and content of orders in the Central Guide supplement. That's a kind of a funny thing. So the way you go to the Central Guide is you go to the court's website, search Central Guide, or just use the words order or something, and they'll bring up some choices. You click on them. We're in the next slide, please, slide 16.
And they're all also the sections of the guide. They're code. They're keyed to the local rules. So if you just go to the front homepage of our website, there's a thing there's a tab up at the top that says something like, rules. And if you click on that, it'll have local rules, central guide, general orders, things like that too.
Yeah, but that's not useful, Judge, because, I want to know everything about an order. I want to know everything about this type of motion. I want to know about a notice of lodgment. The Central Guide will give you the 10 steps I need, because by the way, I'm busy and I got to go do something. On slide 16, some of the other things you had talked about, the title of the order, including a hearing date and, that kind of stuff, and it's there. Let's look at slide 17, Rin. This is a sample from the court's website, which I find to be a little bit troubling for various reasons, but Judge, okay, in the upper left-hand corner, are we going to put the name of the lawyer who's lodging it? I guess the answer is yes, right? This doesn't have an email address. You'd want that on there, wouldn't you now?
And a bar number too. This is an old whatever.
This is an old form from the court site, right?
Yeah.
In the 80s, where we didn't have to put bar numbers on stuff, every now and then someone who wasn't a member of the bar would be filing stuff as a lawyer, and eventually they figured out if you put the bar number on there, eventually it would catch up to you. We have something in the middle that says the Bankruptcy Court, Central District of California. We have different divisions, and you would put that there. If you have something on the left and it's an adversary, you're going to want the adversary caption as well as the Chapter 7, Chapter 11, Chapter whatever, and then both the case numbers that you have there. Judge, if it's an adversary order, I'm uploading it in the adversary LOU, not in the Chapter 7 LOU in connection with that. Now,
Correct.
Here it has a hearing date, time, and courtroom. Again, this is the court's exemplar. I usually put the calendar number. Does that help your staff find what it was that we're talking about?
Sometimes, especially if it's a large case, or if, maybe it relates to a motion, and there've been several of those kinds of motions, or different parties have filed similar kinds of motions. That's unambiguous. We know which motion you're talking about. So it's a pretty good idea. Yeah, not required, but a pretty good idea.
Ren, let's go to slide 18, please. I have problems, everyone has problems, Judge, with some sort of special security system that finds anything in your brief, anything in your lodged orders that somehow reads outside of the box. It takes you someplace else, because that's a classic indication of a fraud or some sort of problem in connection with that. So you basically have to have a document that has nothing in it. But because LOU, you want a Word document, you don't want something that's turned into a TIFF and then scanned to a flat PDF that you can't cut and paste from. That won't work for you, right?
Correct. The converse is true with something you're filing, CMECF. I mean, we kind of want those locked down, if you're filing something that way, because you don't want somebody to be able to call up CMECF and just modify the document and make it say something different. But as far as coming in through our lodged order upload program, yeah, we want it to be Word and clean. So, and I don't want, again, it's all about how much time does it take us to make it say what we want it to say. And if I've got to be turning off track changes and make sure that it's the final version, because sometimes when you've got the track changes going, you end up with something that, yeah, it just, I want it clean. I don't want any of that fancy stuff in my Word document.
So for a while, just a few years ago, we were talking about having a hyperlink to every case that's cited in a brief, so that you can go right to that pin site and read the quote that I'm directing you to. I'm not thinking that's gonna work for a while, because we need to deal with the safety aspects of that. But that sure would be easy, wouldn't it?
Yeah, not for the orders that it's going to be problematic. It's not problematic if CMECF will accommodate that, because that'd be lovely. As you're reading a brief, you can click on the links in that. and you'd know better than I because I never file anything, whether or not you can file something through CMECF with links in it and have the links work. I thought you could. Can we?
Sometimes, and sometimes no. And the only way I get rid of the no sometimes is to completely strip everything out, you flatten it, and sometimes you have to scan it, make it an image, and then bring it back to PDF, and it has nothing, and it works. Rin, let's look at slide 19. In the olden days, Judge, we used to have like a stipulation, classic. We agree that the trial date should be moved out the first date available in February next year. And then you would approve that by signing something at the end. We just put it right on the end. That doesn't work anymore. And in fact, we don't even put a signature line for you anymore in any order at all. Why is that, Judge?
Because that happens electronically. The exception to that is if you're one of those annoying people who's still lodging orders over the counter in hard paper, then I do want a date and a line for me to sign because I'm going to have to actually sign it. If it's coming in through our lodged order upload program, I check a box to say approved. The 3 dashes, no, number signs or pound signs or whatever we call those these days.
Pound sign, probably.
Hashtags, I guess people call them. The 3 hashtags is where the signature is going to end up electronically in the document. And that can't go below line 21, I think it is, or we run out of room. But we can fix that. Yeah, I think I answered the question.
Okay. Rin, let's go to slide 20. So Judge, if I'm doing this electronic thing, I don't need to send you envelopes through some separate mailing to the court or something, right?
Correct.
We have a don't blue back the order, but I bet you half the people on here have never seen or even heard of bluebacks in the olden days. The bluebacks were staple them in a document so you could tell them the different pleadings apart, right?
Right. And since we don't have hard copy files anymore, we only have the electronics. We don't need that. And you wouldn't, what would you blue back? Because if you're doing, ideally you're doing it electronically anyway. So what would you do with the envelopes and the copies and the blue, what would you blue back? I don't know, but it wouldn't work. Yeah.
Ren, let's skip ahead to slide 22.
Actually, wait, before we totally skip over stipulations, I did want to say one thing about stipulations. Some
Ren,
judges
let's
may
go
feel
back
differently.
one step. Go ahead.
Yeah. Some judges may feel differently about it, but yeah, and again, don't prepare a combined stip and order. But what I like in my order, I kind of like the order to actually say what I'm doing, so that if you just have an order that you've uploaded that it said that stip that we filed over there, it's approved. Then if anybody ever wants to know what I actually ordered, they not only have to look at the order, they got to go find the stipulation. So I generally like to have, if you're stipulating that a claim can be allowed in X dollars, I like the order to say, paragraph 1, stipulations approved. Paragraph 2, the objection's overruled. And 3, the claim is allowed in this dollar amount. I kind of like the order to speak for itself, so you don't have to go look at the stip.
Plus, me too, we have a new trial date, but I can't remember what it is. I got it in the order. Ren, let's go to slide 22. We've mentioned some of the mandated standard form orders, or there are a few that are suggested in connection with that. Some judges have orders. Judge Rizzolo has one that he likes for confirmation order and stuff like that. So obviously this is judge specific, but generally, if you've got a standard form order, classic order granting relief from the automatic stay, you're going to use that. And it says, don't change it, don't change it. Now, sometimes, Judge, that doesn't work for me. So I have to take my Adobe after I printed up and prepared it, and I have to X over some crazy line that just doesn't make any sense. And I use giant X's, and I bring it to your attention so you know that. Is that okay? Or am I, I'm violating the rule?
That's okay. Yeah, the key reason for not changing the language is so that we thought it said what it always used to say, and we checked that box and you've changed it. So if you're really upfront about what you're doing and so that we can see you've made a change, that's not necessarily a criminal offense. And then there's always that extra other at the bottom. There's always a spot for that where you can add whatever additional text you need to add as well. Now, I reserve the right to change the language of the mandatory form, and I will sometimes do that from the bench if because I'll have my motions for relief from stay. I have the orders in the queue when I'm hearing the hearings. So I may actually modify then and there, but I'm allowed to do that. You guys aren't. Yeah.
Right. Judge, you're right that we've been covering a lot of stuff that was on our slide. So Ren, I'm going to send you all the way to slide 27 for a minute. Slide 27. Judge, when I upload a proposed order, I get a fancy form and it has a number on it, okay? And that number is a document number. I guess that's a unique key number for that. Ren, let's go to slide 28. And it looks something like this. Judge, do you get something like this in your box, or it just shows up and goes ding, there's an order here?
Neither. We have like a queue. We have a list of orders and they're by number. Well, you can sort them by name or by number or whatever, but they have a number associated with them. That's how I know I'm looking at the right number. So if my clerk is sending me something, if they give me a hard copy of an order, they write that number on it. If they're emailing me to say, Judge, look at this order, they write that number on it. So it's very important to us. But it's useful for you to have it because sometimes we'll be at a hearing and I'll say, well, counsel, have you uploaded an order? Not like you should have, but did you? Because maybe I'm ready to sign it if you did. And they'll say, maybe the lawyer will say yes. We'll say, okay, well, I can't find it. Do you have the number? Because then I can search and see that I actually have. Because sometimes there's a lot in my queue. If I've been very diligent, my staff's been very diligent, maybe there isn't. But sometimes there's a lot in there. So it's helpful to help the judge locate it. And we use those numbers internally all the time.
Let's look at slide 31, Ren, slide 31. If I have no opposition, I file an easy motion and it's a slam dunk and you agree in connection with that, I can just go ahead and upload my order. I'm done. I don't have to go through this notice of lodgment process, which is kind of funky, right?
Well, the local rules tell you when you have to do that. Personally, for me, I'd probably do a notice of lodgment all the time so that you don't mess up and not do it when you should, or that you don't encounter a courtroom deputy who's confused about when you need to or not. And the advantage, again, of the notice of lodgment is that everybody gets served with it so that if you've messed something up or said something I didn't say, they know about it. So I think I was probably one of the people who created that process in the first place. I'm a big fan of the notice of lodgment. So yes, you may follow the local rule and omit
Slide
it when it's
32,
not
Ren.
required.
Go ahead.
But it's probably hard to train if you have staff and you're not doing it yourself. Probably hard to make sure your staff knows when to do it and when not to do it. It's probably easier to just say, always do it. Yeah.
Let's look at slide 34, Ren. Judge, a notice of lodgment is one of those downloadable forms that we have, slide 34, and it has one of those great, easy to remember numbers, F9021-1.2-B.BK.notice.lodgment. I don't know why.
That goes with the local rule that it relates to. That's why they're numbered that way.
It's a good thing. I often it's 2 pages. It's got this first page and it's got a last page, which is a service page. I often take this page, then I take that LOU form with the number, the key number for the document. Then I attach my proposed order that I uploaded. Then I do the proof of service, which is really page 2 of this thing. Then I put the service list I have there in connection with that. And I find that probably helps, but I don't know. Judge, it's having the key number in there help you when I notice a lodgment, or you never look at the notice of lodgment?
I don't look at the notice of lodgment. My staff will look to determine that there is one. So it might be helpful, again, if you've got a case where there's a lot of orders flying around, different parties are lodging proposed forms of order, and maybe there's multiple motions that have similar titles, it might be helpful so that the courtroom deputy who is checking to make sure you did the notice of lodgment can make sure that that's the notice of lodgment that goes with that particular order. So it's not a bad idea. Yeah, not a bad idea.
You're on mute, Scott.
Oh, yep.
Yep.
There you go.
You're supposed to read my lips, Ren. Let's go to slide 40. Thank you. Judge, we're just going to talk about objections for a second, okay? Objections to a form of an order. One more slide for me, slide 40, Ren, please. If I'm there and I'm opposing a motion and I lose because you've ruled in favor of the other party, and then an order comes flying in that I think doesn't comport to what you said, probably expands on your very carefully delineated filing, I might be able to file an objection. And that's a process that involves filing the order that was uploaded and my proposed order, and I do an LOU version for myself so you have it. But you would say, Judge, this is not a motion for reconsideration, right?
Correct. Correct. And a key point is, if you don't like an order that you've seen lodged, call Chambers immediately. because some of us will, I think the local rule still talks about waiting 7 days or something like that for objections, but we don't. We'll just approve it. So if you have, well, I may fix it to make it look the way and frankly, I might, whatever your objection is, I may have the same objection and I may fix it and you may be fine. But don't trust me to do that. Call Chambers and say, I want to file an objection, and we'll give you a deadline. And then you file an objection, lodge your alternate proposed form of order, and then I'll look at the orders and figure out what I ought to do. You're on mute.
You're on mute again.
This is a time when calling Chambers is really important. I call Chambers like right now. I saw that uploaded an hour ago.
Correct.
And I often say, because I'm talking to voicemail usually, I'll have my proposed alternative form of order up by noon tomorrow, something like that. And then I'm going to send it to you. So I'm not saying I'll do it. I'll wait a week and go through that, because then I have to bring a motion under Rule 59 or something to change it. And I don't want to do that.
Right.
Judge, wrap this up. Give us any final tips you have on orders. A lot more to say than you thought when we first started talking about this, wasn't there?
Absolutely. Absolutely. Well, let me tell you about, I don't know if other judges would be open to this, but I saw an interesting process yesterday or the day before that I thought was really fun. There was only one little dispute about the form of the order. The parties had met and conferred, everything else was fine, but there's one line they didn't want in or not. And they did something I've never seen done. It's not permitted under the local rules, but they did it anyway, and it worked. Was on the notice of lodgement, they put like a little footnote or something saying, by the way, the parties don't disagree about whether this part should go in or not. And then in the text of the order itself, it was like little brackets saying, this is, the defendant doesn't think this goes here and plaintiff does. And so I didn't have to read all these other papers. They didn't have to call. It was, so if the parties are working together, maybe you could do something like that. Although, I don't know, would you get a judge who would have a problem with that? That'd be pretty rigid if a judge gave you a problem with that. But anyway, just a thought. So
if we can
yeah.
save you an hour a day on your order review, I mean, we're doing a good job out here.
That's the bottom line, is just think about, are you doing something that's going to aggravate and annoy the judge? Because if you are, that is not in your interest. So put yourself in our shoes from the court's perspective and try to make our job easy, and then we'll like you.
So that's the conclusion of Law and Orders, best practices for drafting, formatting, and getting your orders entered in Judge Bluebond's court. In the bankruptcy court. And we really appreciate your time, Judge. Thank you so much.
Yeah, you are very welcome. Thank you, Scott, for all your hard work on this program too. And thank you folks for showing up and listening. Thank you very much.
Rin, I think we wave and you cut us off, right?